Ready, start. Through the judgment of the case, Sant Rohidas Leather Industries and Charmakar Development Corporation Limited versus Vijaya Bank delivered on March 19, 2026. Justice P. Sri Narasimha and Justice Manoj Misra at the Supreme Court have expressed the view that the National Consumer Disputes Redressal Commission NCDRC at New Delhi was justified in dismissing the complaint even though the reasons recorded by it for such dismissal may not be entirely correct. Para. The statutory appeal in this case arose from a judgment and order of the NCDRC New Delhi of March 13, 2023 in Consumer Complaint 2866 of 2017, whereby the consumer complaint was dismissed on the ground that the complaint the appellant herein is not a consumer as per section 2 subsection 1D of the Consumer Protection Act 1986 para. The appellant company filed a consumer complaint against Vijaya Bank alleging that it had invested a sum of rupees 9 crore by way of a fixed deposit with the bank for a period of 1 year with effect from February 28, 2024, and evidencing a transaction of fixed deposit receipt of March 3, 2014 was issued to the appellant, and even the interest payable on the said FDR was credited in the account of the appellant on March 26, 2014 after deducting TDS. However, on June 27, 2014, the appellant received a letter from the bank about sanction of a loan credit facility overdraft of rupees 8.10 crore against the FDR, suspecting foul play in sanction of loan credit facility overdraft against the FDR. The appellant lodged a complaint with the Economic Offences Wing, Crime Branch, Mumbai on July 16, 2014. A letter was also sent to the bank to reverse the entries the fraudulent overdraft account. The bank, however, did not accede to the request. Para. As a result, the matter was reported to the Reserve Bank of India. Subsequently, on March 4, 2017, the bank informed the appellant that the overdraft facility has been closed by adjusting the amount outstanding thereunder against the maturity value of the FDR, and the remaining balance of rupees 50,58,000 was remitted via DD number 245983 of March 4, 2017. The appellant neither accepted adjustment nor remission and requested the bank to make payment of the entire FDR amount. As the bank failed to refund the amount, consumer complaint was filed with a prayer that the bank be directed to pay the principal amount of rupees 9 crore along with interest at the rate of 9.75% per annum from February 28, 2014, along with compensation as well as costs. Para. The bank contested the complaint on merits as well as on its maintainability on the grounds. Para. The allegations of the fraud, forgery, etc., can be decided either by a civil court or a criminal court and not in summary proceedings under the 1986 Act, and the complainant company is engaged in commercial activity. The alleged investment was to augment profits. Therefore, the complainant is not a consumer as defined in Section 21D of the 1986 Act, para NCDRC, by placing reliance on the definition of consumer as defined in Section 2, subsection 1D of the 1986 Act, as also a decision of the Supreme Court in the case Lilavati Kirtilal Mehta Medical Trust versus Unique Shanti Developers and other civil appeal number 4841 of 2023 held that the deposit made by the appellant with the bank had a direct nexus to generation of profits, that is, earning interest on surplus funds. Therefore, the banking services were availed for commercial purpose.